Hi, I'm Jamie Johnson of the Johnson Law Firm, where we do estate planning and probate, and we do it well. Today I'd like to talk to you about whether or not you need to actually have a lawyer to make a will or a trust. And the short answer to that is no, you don't. There are lots of DIY CDs and fill-in-the-blank forms that you can get at a Staples or an Office Mac or other stores where they sell such things. There's also online companies, as well as if you Google it, I'm sure you'll find something, make your own will for $75 or $100. A lot of those are fill in the box and hit print kind of services that can get the job done right, but you need to make it doesn't provide any actual legal advice. It's just literally a fill in the blank and hit print kind of service. In Virginia, what you need to make sure is that you hit the requirements that are necessary for a will to be valid. For that, the person must be over 18 years of age. They must be of sound, competent mind, be aware of what they're signing, what it involves, where their assets are located, the approximate value of their assets, and the fact that, what they're doing with those assets, who's getting what. When the will is being signed, it needs to be signed by the testator, which is the person signing the will. It needs to be signed in front of two witnesses, who then sign the will in front of the testator and the other witness. And usually needs to be notarized. It's not required that it be notarized. The actual requirements of Virginia are the signatures by the testator and the two witnesses in front of each other. However, where this can lead to problems is when the will actually goes to be probated. Obviously, the testator has already passed away. The two witnesses have to be found, located, and come in and test the fact that they are the person that signed the witness form, and yes, in fact, that the testator signed in front of them. Unfortunately, this can be an issue, as I've found out recently, because I had a client who came in. Their uncle had passed away. He had done his own will. It was signed by his two neighbors. Unfortunately, when he passed away, he was in his 90s. His two witnesses, his neighbors, had since moved from Virginia to Maryland. The husband had passed away a decade earlier, and the wife now had Alzheimer's and could not remember the signing of the will, which means the will was not validly probated, could not be probated, and therefore he was deemed to have died intestate, which meant instead of his fiance receiving the money through the will, the money actually went to his sister, who was 97 years old and living in a nursing home. So instead of his fiance getting money, it went to his sister, and then that money promptly turned around and was turned over to the state because it was there to reimburse for the nursing home. So whether or not a will is properly executed can be a huge thing and swing hundreds of thousands of dollars in different directions. That's why it's recommended that if you're going to execute a will, go ahead and go to an attorney's office. They typically have notaries. They will notarize it for you. They'll make sure that it's being executed properly, and then you can assure that the will be validly probated. Although you can save money by not going to a lawyer, one of the benefits of a lawyer is that a lawyer will ask those questions that don't come up in the pre-fillable forms. Things like, what are your intentions? What are your goals? Not just, who do you want to give your money to? There's a difference between who you want to give your money to and what is your goal. Because when you're listing your goals, there are different ways in which to accomplish them, and an attorney can walk you through those different ways. Also, the attorney can point out the pitfalls that you might be looking at in terms of tax issues or creditor issues and things of that nature that only an attorney would be able to help you with. The DIY forms and the online forms are not going to be able to help you with that. So even just meeting with an attorney can be beneficial if it's your intention to do the DIY forms. Now, most attorneys will not review the DIY form and then have you sign it in their presence, because that can create some ethical issues for them. However, usually an attorney is happy to meet with you to discuss issues regarding a will, and then you can go out and do your own DIY form if you wish to. I think that you actually find that attorneys are not that much more expensive than the DIY forms. You get the benefit of being able to ask them the questions and make sure that everything's being executed properly. So if you're trying to avoid the common pitfalls and mistakes, highly recommend that you speak to an attorney, at least discuss your will with an attorney. And if you wish to go the DIY route, you can do so. Just make sure that you hit the necessary requirements that Virginia has. If you have any other questions or concerns, feel free to reach out to Johnson Law Firm. We'd be happy to answer them for you.